Oh my. I'm all kind of discombobulated. Ladies and gentlemen, welcome to the show. It's Saturday morning. I have some court cases to watch. I have a loudspeaker. And I have nothing but time. And we all have a lot of court to watch, so I'm not going to beat around the bush. This is kind of a catch-up / wrap-up of the frustrating landlord, lawyer, agent who has been trying to sue for non-payment of rent against some University of Michigan professors. It's a whole, kind of professor drama ordeal. We've seen this lawyer before in some very, unique outfits and scarves, and she's very frustrating. I missed one case of hers back on July 12th, so we're going to go ahead and watch that one in addition to the case that she just had yesterday with the same plaintiffs and defendants. It's all interesting. We're going to wrap it up at the very end because it's gold, but it's frustrating gold. We're going to wrap it up with some Judge Fleischer fun and goodness. Actually, I'm not going to say it's fun because it's kind of sad for the people involved, but it's absolutely some interesting cases all the way around. It's not going to be his whole docket, to say the least, but I've cherry-picked some good cases from yesterday's docket, ones that definitely piqued my interest when I saw them. So we're going to get right into it, and we're going to enjoy some court cases with two of our favorite judges. Let's get started, shall we?
What is she doing? What is she doing? Just walking across my well. Alan, take her down. Alec Jerome versus Eric Cassidy. We set the motion.
Yeah, so that it's,
Okay.
yes.
Okay, that's what I thought. All right. Counsel, state your appearances.
Donna Tope, I'm here on behalf of the plaintiffs, Alec Jerome and Caroline Jerome. They are here by Zoom.
Yes, I do see that.
Good afternoon, Your Honor. Francie Novar appearing on behalf of Eric Cassidy. Gail Rosen from University of Michigan Student Legal Services has filed an appearance on behalf of Paula Cassidy. However, Ms. Rosen is at a conference this week, and so we are proceeding without her presence.
All right. I think the first order of business that we have to take up is before it goes any further, is the motion, I think, filed by Ms. Rosen. So I don't know, counsel, if you were going to, well, who was going to argue that motion? She's not here.
I'm fine arguing the motion, Your Honor.
All right. And counsel, you received a copy of the motion? Okay. I did not get a response to the motion, but
I haven't had a chance to respond, but I will today.
okay.
Your Honor, I did also mail the motion on Monday and email it as well.
All right. Well, without here, I've reviewed the motion and I don't need much argument unless somebody wants to argue. And I guess, Mr. Tope, I would ask why wouldn't you be disqualified as counsel? I guess I'm going to start there. I'm going to.
That's fine, then, Your Honor.
First, because, sorry about that.
What would
Why wouldn't you be disqualified as counsel in this case?
Your Honor, their counter complaint is this, their complaint or their motion to disqualify me is premature. It's not right. There's no certainty that the cases will go to trial. The plaintiff's right to the legal representation of their choice would be irreparably damaged if their attorney, me, were not there to represent them during the preliminary steps before trial. If the case does go to trial, defendants can make the motion then. The defendants claim in their brief that there is a conflict of interest. A conflict of interest does not exist. I, Donna K. Tope, MSJD, has no legal or personal relationship with the defendants in this case. Donna K. Tope, as plaintiff's property managed agent, has no legal or personal duty or legal relationship with the defendants of any kind. The legal brief is an error. Donna K. Tope, MSJD, me, the plaintiff's attorney, is not a party in any of the Cassidy's legal filings. Their counter complaint is against Alec Jerome, Caroline Jerome, Cambridge Family Holdings Property Management Company, and Donna K. Tope, the Jerome's property management agent. The complaint is a documents case. It is a landlord tenant case for non-payment of rent and termination of the lease. And that the Cassidys violated several terms of the lease between landlord owners Jerome's and the Cassidys.
Okay, Mr. Let me stop you for a moment.
Mhm.
On some of that, you may be correct. But I think the biggest problem that I see, and there are a number of them, but the biggest problem I see is you representing in a case in which you may be a witness.
And my next point is directly on that point. And that is that the case is based on the Cassidys withholding all rent and utility payments, beginning with those due September 1st. The defendant's defense is limited to the legal basis for the claim that those repairs were so egregious and made the home so unlivable so as to rise to remedy of withholding all rent beginning December 1st. There are 4 different witnesses. They have filed the case against Alec Jerome, Caroline Jerome, Cambridge Family Holdings, and Donna K. Tope. All 4 of those people could be witnesses for any of the evidence.
But counsel, that doesn't negate the fact that you could be a witness.
I'm not an essential witness. There are 3 other people.
But hold on, I think that you are if what's contained in here is correct. And that is that you're having these conversations with the other parties.
I'm having these conversations. Could you be a little more specific?
Well, but you're arranging certain things. You're the one talking to them. You're the one dealing
As
with
the
them.
agent is, okay.
Right. I get it. I get why you're doing it in that capacity. I don't
Right.
have any issue with
Okay,
that.
I'm just trying to understand.
Right.
What
What I have an issue with are the rules of professional conduct, particularly, and then you representing a party where of rights, because of a conversation that might have ensued, you would be called as the witness. That's a problem.
Okay, the rules of professional conduct, and that is where that is behind what I say that the brief of a conflict of interest does not exist, is because that an attorney in a party to a suit cannot be a witness. I, Donna K. Tope, MSJD, am not a party to any lawsuit that they have.
No.
filed.
But the rule also indicates you can't be the attorney and witness.
The other three parties are
You,
the
but
best, really the best
Coun-
witnesses
counsel-
because they're the
counsel-
landlords.
counsel, just by being here the number of times that we've been here, what's clear to me is that you're, just by way of example, you've got conversations or have conversations that you've had with the Cassidys directly with Eric and Paula Cassidy.
Not as an attorney, only as the property management. And they are all related. to
Right,
property
right.
management.
But it almost would be better if you had it as the attorney, because that puts you in a different boat. It's precisely what you just said that causes the problem. You are having these conversations, negotiating with them, imploring them, taking their complete, hey, hold on.
I'm not negotiating. I'm just managing the property.
Right. But in that management of the property, you're having the conversations with the tenants.
Through their attorneys, always. Now, once these cases began, I do everything through the attorneys as well.
They didn't always have attorneys,
No.
right? You dealt with them directly.
Neither did the Jeromes.
Miss Tote. Miss Tote. I think, let me just be clear about this. I am loath when an attorney comes before the court to disqualify an attorney ever. I just am. I think attorneys, we're in a profession that is in a lot of ways self-governing. So if there is a conflict, I mean, if you just take the basic structure and you say that if I am an attorney in a case and I could be a witness to something in the case, then you almost have to rely upon the attorney not to enter into representation. Now, having said that, and so typically attorneys won't, right? And so I don't like, because I think attorneys have to make that decision a lot of times on their own, right? And so I don't like to get involved in that. But when it's brought before me that an attorney is going to be a witness in the case, and the other reason I don't like it is because sometimes that can be used from a tactical perspective from one side or the other. And so I went through this in great detail. And quite frankly, trying to find a way that would preserve your ability to represent these individuals. That's really how I approach it when I'm reading it, right? Because what I say to myself is, if an attorney isn't supposed to be in a case, the attorney is going to get out of the case. This other side's filing this to get this other attorney out of the case. So I'm going to operate on the presumption that the attorney should be there. When I finish reading this, and then also knowing and having been here and heard the case, I'll be absolutely honest with you. I don't think you can represent the parties in this case, because you are clearly, in my mind, going to be a witness. Now, I'll stop you, hold it before you say anything.
That's if we go to trial.
But here's what I don't want to end up in. But there can be certain points before trial. In the way I operate my cases
Mhm.
where I set them for final settlement conference.
Right.
And the thing in certain.
Yeah, no,
representation.
I would be acting as their attorney in those
Right.
pretrial.
Well, the problem is I may ask for certain representations from the parties. Right. I don't want to.
I understand. I get exactly that. There is a problem there because you would be talking with them from, I get that.
And I don't want to be, so the interesting thing about all lawyers are bound by this, that if I see a violation of the ethical rule.
Yeah,
I'm then.
that would be,
Hold on, I'm then required to report.
okay.
So I do not want to be in a position where I have to report you. I don't do that unless I absolutely
Oh, well,
have to. And
thank you very
do not
much.
Want to do that. I wouldn't want to do it to anyone.
So can I just want to suggest that those kinds of, your kinds of reservations, your kinds of concerns would not apply if the Jeromes were representing themselves. And yet they still are going to be witnesses in their counter complaint.
That is absolutely correct.
Okay,
It wouldn't apply to them.
no,
It doesn't.
no, because they're not attorneys under the attorney. Well, I still say that I would like you to wait until we actually come to that Waterloo. But I know that, because we may not, I mean, we were hoping that we could get some kind of meeting of the minds at this discussion that occurred without attorneys at the University of Michigan legal department's discussion, dispute resolution meeting that took place. And we did not. But if a settlement does occur before I have to come in a legal court proceeding representing the Jeromes, then I wouldn't have to disqualify myself from advising
Ms.
them.
Toth, I'm gonna have, I've been doing this a minute.
Yeah,
And I'm just gonna tell you, I'm gonna see it on motions. I'm gonna see that
got it,
this issue get raised.
got it.
The moment an affidavit's filed.
Yeah,
We're gonna have a problem,
yeah.
right?
I totally am understanding your issue.
And so I don't want, everybody has a right to have their cases heard expeditiously to get through them. And I just don't think that can happen in this case. with
Given what's
you
going on.
Representing them, because and here's the other part. The other part is this is a summary proceeding and maybe one of the thickest or second thickest I've had this year filed. But summary proceedings operate at a different pace. We operate rather quickly. The moment they file a motion, file an affidavit alleging that you said we got a problem.
Yeah,
And then I have to put it on hold, which is not, quite frankly, in your client's interest. I have to put it
No.
on hold, waiting for an attorney to come in to just answer the motion, let alone argue.
okay.
Because you would place yourself in a quandary by even trying to answer.
No.
You follow me?
No, I absolutely,
Okay.
absolutely. I mean, like an arrow to the heart.
Okay. Well, don't put it that way.
No,
It's gonna,
I just gotta say,
yeah,
that's what it feels like, but
okay.
I totally understand.
All right. So I guess my question is, if you, rather than me even ruling on this motion at this time, but if you were, how long would it take for you to find counsel to substitute in?
I will talk with my clients and we will have a speedy discussion because they are on it. And I can get back to you within several days.
Okay. I won't ask this side to the Jeromes. Do you, based upon the discussion, I realize you guys aren't lawyers, so did you have any questions with anything that the court was saying or anything that was going on there?
Alec, did you want to? I think it's clear. I think I understand what you've said. Thank you, Judge Simpson. And yeah, we can confer and we'll figure it out. You know, there is always a lawyer present just because of the nature of the tenants, but we'll find another lawyer that will work and won't cause a conflict. I understand that's super important.
Yes. Okay. So. Yes, ma'am.
You did understand what she said, that in every situation involving the tenants, there is a lawyer present on their side because Eric is a lawyer and he has sort of, yeah.
Right. And if
he's
and
inserted lawyerly things into the discussion.
I get it. But
Okay.
But if he were representing, quite frankly, he might have a problem if he were to step in and represent even his wife in this. He could certainly represent himself. I mean, that's he could do that, but that's not what this is.
Yeah.
Right. And I get there's always a lawyer involved. Sometimes you throw a stone, there's a lawyer involved. So
Mr. Cassidy is licensed in the state of Texas, not in the state of Michigan.
State of Texas, my condolences. All right, so that's it. So I guess my thought process is to adjourn this out a couple weeks, allow them to substitute an attorney in even before I rule, so that way we're not even trying to do things right now that may cause problems later. But I don't know how you feel about that. We like having you here every couple weeks or so, but
Your Honor, I mean, we really are asking the court to make the decision today, and I think an email that we received last night from Ms. Tope at like 11:30 p.m., coupled with the motion that she filed a few days ago to allow the landlords to repair the property without the tenants present, show how integral she is and what a fact witness she is. She's, in our opinion, the only fact witness. We don't need anybody else. Not to mention the fact that most of our counterclaims are against her individually.
Oh, I know.
Emotional distress and whatnot that we're going to file is against her.
I know.
Individually. And she has a clear conflict of interest because I presume the Jeromes are going to distance themselves from her and say they haven't authorized the behavior that she's been doing on entering onto their property.
And those are all allegations.
I know. And look, folks. All right. Maybe my problem with being a judge is I'm a lawyer's judge.
Is what?
I'm a lawyer's judge. I love the practice of law and I like watching lawyers practice. And where I don't have to enter into having lawyers do the right thing or whatever, and I don't. I think you had Ms. Tope a certain position that you had. We had that brief interaction we just had now. My understanding is that there will be an attorney substituting in. So what I'm going to do is, this is how I'm going to leave it, because I do understand your point, but You have 7 days to file a substitution of attorney. If not, the court will enter an order granting the disqualification of this. Just do it that way. All right. You're welcome. And I'm not going to proceed on anything else until I have different counsel on this side.
Okay, so they would have to refile my motion that to have the tenants vacate while the landlords do.
No, I mean, I'm not, because, no, I'm not going to require them necessarily to refile. They're going to have to sign something
Okay,
for that motion under the court rules because it has to be their motion.
okay,
They don't have to absolutely refile it. I'm not,
excellent.
I mean, there are ways around that notion without
it's-
causing undue delay.
Yeah,
All right?
thank you.
So what I will do, and if council, if you would prepare the order that there will be a substitution, right?
Yep.
Or that the court will be granting that. So that order needs to be prepared, submitted to the court. I will adjourn this out 2 weeks. And we
Judge,
will come back. And I'm sorry. Yes, ma'am.
I'm being a little sister. My brother has had his hand raised because he did want to also.
Oh, I'm sorry.
He was-
I didn't.
That's okay.
I'm sorry. I wasn't
Um,
looking
so
at that screen. And I
That's totally
apologize.
cool. Totally cool. Okay.
All right.
Alan.
So you said you were being a little sister when you did that?
Speaking up for my
I
brother.
wasn't
my
speaking up. I
brother.
did have my
You
hand
know,
raised.
no, it's okay. I have one of those and you're right. I get him. He's big brothers were just quiet until our little sister says, gotta say something.
Okay. I'm back.
Go ahead, sir.
Your Honor, the only point of question that I had was related to, we actually came today prepared to make an offer for settlement of the situation related to the payment of all of the rent, back rent, penalties and fees, but absolving the Cassidys of any of the penalty related to the forfeiture or breaking of the lease, which was in the neighborhood of, I believe, $26,000. Does that make a difference in terms of having a discussion or not?
Yeah, no,
Ask that the record be stricken on this in terms of any proposed settlement that we have.
yeah, in the court, its head is not, I'm not even dealing with that. The short part of that is you came to try
Yeah.
to look to negotiate it. What I'm going to suggest to you is just hold it for a minute in terms of what position you may want to put forth. Let's get other counsel in to do that who can also look at it. And then if that's still your proposal, certainly there'll be time to submit that to the other side.
Yes,
All right,
Okay.
thank you.
we're heard. Alec, you were heard.
All right? Yes. All right, folks. Thank you.
Thank you, Your Honor.
Thank you. All right.
4 to 6 weeks later.
Let's call the case. Alec Jerome versus Eric. Alec Jerome et al. Versus Eric Cassidy. Two cases. Got counsel, and then they've got, are they both? Okay, I do have Mr. Okay, because Mr. Cassidy's usually here, but he's not here. He's there in there. He's just trying to mess me up. All right, and they do have both the Jeromes. Got it. Okay.
Good afternoon, Your Honor. How are you? Gail,
I'm about to find out. I have.
Gail Rosen appearing, Francine Nova appearing on behalf of the defendants.
Okay.
I'm Donna Toth. I was the attorney for the Jeromes. I am now a plaintiff. The Jeromes are here by Zoom and we are in pro per.
Well, hold it. You're a plaintiff? yourself?
Yes, they counterclaimed and
Oh, okay, got it.
it's complicated.
Well, not really. So
If I could, Your Honor, just what were,
I just want to know who has been representing the Jeromes.
They are representing themselves.
Is that correct?
That's correct.
Yes, Your Honor.
You're going to represent yourselves?
That was the idea.
Yeah, I'm
With
not sure whose
Donna
idea.
With,
Pardon?
that was the idea with Donna as our agent, because she managed everything for us. So yes, that's where we are.
Okay, but okay, I just want to make sure you're going to represent yourselves in the legal proceeding.
We're representing ourselves today. I don't know. I mean, what I'm hearing from you is that perhaps that's ill-advisable. But yes, today we are here just representing ourselves.
Okay, no, I didn't mean to say either way, except that I just want to make sure I'm clear that from a legal standpoint, you guys are representing yourselves.
That's correct.
But you're doing it for today for sure, but it may change.
Yeah,
It's
yes,
up.
sir. Yeah.
Got
yes.
it. I got it. Okay, now,
so we're here on two motions, I believe, but before I get to those motions, if I can provide a brief update to the court.
sure.
So I just wanted to let you know that, or the court know that in July, the tenants advised, as did I, advised the landlords that they would be vacating the property prior to September 1st, 2024. Provided notification 2 months ago to give the plaintiffs an opportunity and significant time to find new tenants before the start of the academic year. So the tenants have found alternate housing and they will vacate on August 31st and return possession of the property to the landlord. I'll need to know where to leave the keys. And they'll continue to comply with the court's order to pay rent into escrow until the case is decided.
Okay.
So just as a, go ahead.
No, I was gonna say.
Just by way of the reasoning is that they contend that they've been constructively evicted, not only as a result of significant delay or failure to address a plethora of necessary repairs, but also due to substantial privacy violations and a violation and interference with their right to quiet enjoyment. Ms. Tope has routinely noted that she frequently conducts what she calls security checks at the property, as well as what she refers to as due diligence, surveillance, watching the property from the road. So I'm not aware of anything that allows that to occur. Additionally, she's falsely filed a police report accusing the tenants of assault, filed a PPO making the same false allegations, and now filed a case in circuit court, similarly falsely accusing the tenants of assault and battery. So that's
Excuse me. There's a new filing, or is
in
that,
circuit court, yes.
okay, so when did that happen?
I'm not sure when that was filed.
It's a civil case.
Okay, I understand
And
that.
it has nothing to do with the landlord tenant issues that are before this court.
We'll come back to that.
So the good news is that
There's gonna be some, go ahead.
since the tenants are vacating the property in about a week or 8 days, plaintiff's motion to enter the property unimpeded by the tenants and their dogs is moot. So they can enter the property after August 31st without any fear of interference from the tenants.
Okay.
So we just have our motion then to strike the plaintiff's report to the court on mediation. I believe.
Before we get into that,
Sure.
this is where this gets a little bit weird. Did either of the other parties have anything to say about the vacating the premises and the like? I guess the only people that wouldn't. Well, Well, I'll hear from anybody. Ms. Tope.
I'm the agent who has managed the entire lease from the beginning to the end and had all interaction on the lease and its terms and meeting the responsibilities of the landlord as their agent. I did that. And as far as the request or the assertion that the plaintiffs were leaving the property September 1st, they have not requested nor gotten written permission to terminate the lease. And they have not,
See, this is where this gets weird. Okay,
okay,
because I don't, as you stand here before me today,
yeah.
how are you asserting that on behalf of the Jeromes?
As the agent who has been completely involved in the entire performance of the lease from the standpoint of the tenants.
Okay, that's why, as I said before at the last hearing, that we actually were all here,
Yes,
this gets messy. Because that notion, certainly you can say up to a certain point that's occurred. However, it's really up to Jerome's to say that.
Okay.
well,
No, I mean, it is murky because, of course, as our agent, all these, from our perspective, all of these things are allegations we're not there on the ground to see.
Yeah, okay, and that's, let me just stop you there, because I think
it seems to me that
it
these
would,
issues for trial as opposed to being.
what issues for trial? Well, here's what the
their
issue for trial would be.
complaint. These are
Whether or
all
not they were
issues-
constructively evicted, they're leaving. If you listen to what Ms. Wilson said, they're not seeking your acquiescence to leave. Their belief is that they've been constructively evicted from the premises.
Your Honor, if I may, my intention was to notify the court and provide an update on what's happening to date. They're leaving. The motion is therefore moot. And whether or not they've been constructively evicted will be determined by this court. We're not
Absolutely.
asking the
Right.
plaintiff's permission. They're leaving.
That's why I consider that to be an issue that needs to be decided down the road, as opposed to how did the Jeromes feel about it? I think that they will assert themselves
Okay.
at that time.
Counsel, this is where our problem is. You can't. You're holding way too many different roles. I don't know when you're talking to me, whether you're talking to me as an attorney in the case or as a party in the case, but it worries me because of this court's order.
Yes.
When you're talking about something, making a representation as to almost representing the Jeromes, because that's going to be a problem.
Okay, they have counterclaimed against the Jeromes and me. And these are issues in their counter complaint that all of the
Okay,
things that I.
I didn't want to say this, but here's what I'm just going to say. Here's what the problem is, counsel, and why I did what I did. The problem is that, as Mr. Jerome was saying, they weren't there. So let's assume, for the sake of argument, I'm not saying that it's the case, that you did something that was where all of a sudden they're liable for it, and they didn't give you authorization to do it. And if that happens, you guys are on way opposite ends of that legal perspective and argument.
Wouldn't that be part of their counter complaint, which is a
I'm not even getting to the counter complaint. I'm just getting, you're standing here making representations on behalf of the Jeromes under the guise of being their agent.
right? Because I was involved in all of
However,
it.
If I could just add to, Your Honor, the mediation, the report to the court, the mediation summary was also drafted and filed by Ms. Toth. The motion was, the response to the motion was drafted and filed by Ms. Toth. So,
what was the song?
Yeah. I hope it's inspirational.
so it's even murkier.
I wanted to put on a flannel shirt and go outside. Put on a hat. No, anyway, I'm sorry.
It's even murkier, Your Honor, in terms of where the representation begins and ends, and that's
I know.
where we filed the motion to disqualify Ms. Toth as their attorneys, and you granted the motion to disqualify Ms. Toth.
Your Honor, may I say on behalf of Mr. Eric Cassidy that we believe that Ms. Toth has completely violated your order. She continues to represent the Jeromes. By saying she's an agent does not mean that she's not doing legal work on behalf of the Jeromes. They admitted it themselves today. This needs to stop. She should be sanctioned, and we need to move forward with the trial in this matter.
The motion that is before you was a motion that I filed when I was the attorney. I no longer the attorney, but in your order, you said that we could pursue that motion, and you set it for a hearing today because you did not want to jeopardize the Jerome's rights. That is the motion that I put into notice for this hearing. And these other things sort of fall behind that. So I sort of am, I have been put into that position, this position, by filing that motion. And so I'm responding as the person who filed that motion that you allowed us to continue to present before the court on this date.
Your Honor, that motion is moot. And
It's not moot because they haven't left. And
moot next week. And additionally, after the disqualification order was signed, Ms. Toth filed an amendment to that.
No, I know.
To that motion, and then a response to our motion to strike. So it continues, and there's quite a lack of clarity as to what Ms. Toth's role is in this matter.
And Your Honor, I think it's willful at this point. She knows. She's been in this court and in front of you long enough to know that you told her not to do that. There's a clear conflict of interest between her and the Jeromes that will be apparent at trial. So she's not only having the conflict of interest, but she's a witness, and she's participating as an attorney for herself, an attorney for the Jeromes still to this day by her last two pleadings.
the response to the letter was because I, as their agent, set up that dispute resolution settlement meeting. And so I feel I set it up with the University of Michigan because it's a term in the lease. And so I felt like.
But Your Honor, it was filed on their behalf after she was disqualified.
Oh, I know.
And it was also a completely improper filing. There's no, I don't know why a report was just submitted to the court on facts that the court wasn't seeking information about. It doesn't ask the court.
That's in our answer, my answer, because I'm the one that had it set up, and I'm the one that got affirmation from the director who set up the meeting that it was not mediation, it was not legal mediation, and the assertions that were put into their motion to strike were not accurate.
Your Honor, Ms. Tope wasn't at the mediation. That was the point. It was the plaintiff without Ms. Tope. She prepared their affidavit. She filed their affidavit. It is mediation. The court ordered mediation. This is all a type of mediation that was provided. The parties agreed to it. The parties signed a confidentiality agreement that applies to the entire process of the mediation.
And our answer answers that because he directly said, and
let's not.
that it was not mediation and did not have any legal import, and that they would not file a report with the court.
They would not file a report with the court because it's confidential. They signed an agreement that said it's confidential. The court rules provide that it's confidential. The rules of evidence provide that it's confidential. And now you're trying to get that information in yet another time when the information is confidential and shouldn't be. And we requested that it be withdrawn.
Can I remind the court that Ms. Tope tried to get this information in last time at the hearing, and I objected as this was information to settlement discussions, and Your Honor said, yes, I'm not hearing any of this. So she turned around and put it in a writing and submitted it. And MRE 408 does not say mediation, it just says settlement discussions cannot be before the court.
And the settlement discussion, nothing about this, Your Honor, nothing about the settlement discussions was disclosed by the Jeromes. What was in their letter, they described to you that they did discuss the issues of the landlord-tenant case that was presented to the dispute resolution people. Assistant. And it was Mr. Cassidy who went off the rails and talked about things that had nothing to do. No, they drafted that letter. It's their words in that letter.
So if I can renew my.
Can I just, hold on a second.
Certainly.
Ms. Tope,
Yes.
I don't like finding that attorneys are violating not only the written orders of the court, but certainly the spirit of the court's orders, and are trying to go around that. And when this whole thing about the disqualification started, what I honestly thought was that, and I ultimately ordered and was waiting for, was a substitution of attorney, because I didn't want the Jeromes being without counsel.
And I have searched far and wide among all the landlord-tenant attorneys who have appeared before you, and nobody wants to take this skillet of snakes. I have an attorney who is not part of the landlord-tenant attorney group, but she has not been able to file an appearance for me because she was in court today.
But is that for you?
Yeah, she will represent the Jeromes as well, but she's not able to.
Whoa. Okay. Stay with me here. Stay with me here. Stay with me here. I don't care who the attorney is.
Okay.
That attorney
cannot represent
both. There is, even from what minimally I know about this case, just from the plea, that can't happen.
Okay.
And I'm not going to allow that to happen.
Okay.
Because I think, quite honestly, and I didn't want to say it out loud, but I'll just say it out loud now. I think the interest of the Jeromes are going to, at some point, be absolutely in direct conflict to your own interest.
Understood.
Okay. No, I value your advice, every word that you've
I don't
told
give
me.
advice. I give opinions and orders, but go ahead.
Okay.
Ms. Tope,
Yes.
you need to just stop.
Okay.
No, you need to stop doing what you're doing in this case. You can certainly defend yourself. I'm not entirely clear of the relationship that you have with the Jeromes, but I will just say that what is happening and what you're doing is potentially jeopardizing their positions in this case, as well as your own.
I hear what you're saying. I intellectually do not understand because,
Just
handled the
basic,
whole-
just basic.
okay,
If you did something
yes,
that they did not implicitly or explicitly give you permission to do,
right,
that then would, because you're acting as their agent and it causes liability to the Cassidys. You with me so far?
so far,
They come after you because they didn't give you authority to act.
they meaning,
The Jerome.
oh, because they're going to go after.
Because now all of a
Jerome
sudden
because
they're
of something
like,
I did in
Pardon?
performing the lease. Because they are going after me for something I did in executing the terms of the lease that I signed.
but they're going after not only you, they're going after the Jeromes. And the Jeromes may have said, oh, she was supposed to do that,
Yeah,
right? And that the Jeromes, I'm gonna presume, are gonna say, we don't want liability for that. She didn't have authority to do that.
right.
And
So it's on me.
yes, let's presume it comes out that way.
Yeah.
The problem is when you're representing them, that will never happen.
As the agent
No.
who
no.
signed the
As
lease.
as you're representing them and making the statement as though you are one in
Okay.
this court, that will never happen. The fact that that can't happen or won't happen is where there is jeopardy and prejudice to the Jeromes in terms of what their position might ultimately be.
Okay. The attorney that I have retained, if she represents the Jeromes
She
and
won't.
I represent myself.
So weird.
I
No,
know
no,
it's
no, no. I
weird.
think,
It's
can I
weird
just
that you're-
interject?
That you're retaining the attorney. That's
I
just so strange to me. I'm
Yes,
sorry.
no,
Miss-
we are,
Yes, go ahead.
okay. You've made it abundantly clear that we will retain our own attorney. And
Wow, somebody actually is listening to me.
and
all
I
are
really don't
listening.
know what, well, I finally got it. And we'll have to proceed from there as far as the things that are on the agenda today. I know that our contract does, I guess this is an anticipatory breach of the contract if they move out. But again, I would want to have a lawyer here to talk about that. And, I am understanding some of the language that's going back and forth between you and the attorneys for the Cassidys. But we're going to have to prepare ourselves to distance ourselves from Ms. Topin. So I'm comfortable with that. And I'm sorry it's taken us so long to get there. Alec, do you have anything to add to that?
No.
Okay.
He's a good husband.
Yes. No, he's a brother. He's
What'd
a
you say?
brother.
Your brother?
My
Yeah,
brother.
okay, then he's very good.
Yeah.
Like,
Yeah.
He's a good brother.
sister asked, do you have anything to add after I talk? No. All right.
He is. They are. They're great people. Okay.
Okay, so when speaking to the Jeromes, how long will it take you to get attorneys? Because it's going to be very difficult for me to move forward unless I'm sure you've got attorneys that are.
They will have an attorney within.
Why are you answering for them?
Yeah, no, I got
Because
this
we've
one. I got this.
Your Honor, we have talked about this. We have talked
What
about
did I just say to you?
in the past.
Oh my gosh, look.
Yeah, no, I just to interject again. Alec, it's the 23rd of August. I would say after I have 11-year-old, she's beginning school. Could we put it into the beginning of September? I would think that we should be able to find some.
Okay,
then.
let me ask you this. Could you guys have an attorney in, say, 2 to 3 weeks?
Yes.
She just
3
said,
weeks,
Normal.
please. Yes.
3 weeks? Is that gonna be tight for you? I don't want it to be tight for you. I'm just,
Alec, what did you say?
I said 3 weeks. I would like the latter of that range if possible.
okay, so at least 3 weeks to get you, okay, very good. See, I knew he'd say something eventually. So, okay, all right. So, all right.
So I do think, Your Honor, our motion to strike is pretty straightforward.
Yes, it is. Okay, so, and this is what I don't understand. Why do I have a report to me at all?
because in typical actual legal mediation, the mediator gives a report. And because it was my understanding from talking with the Jeromes after the session that I had arranged for them, things went much further than the subject of the meeting was supposed to be. And it was
I think that I
discussed with, go ahead.
Yeah, I just wanted to say that, when we talked and reported, Donna was still our attorney. Alec and I, in our ignorance, didn't know that. I guess we should have thought about it, but since it wasn't an official mediation, according to the agency who conducted it, there was an email that said that we didn't think there would be a violation, and didn't know that it. Again,
We didn't discuss terms of the tenant lease.
Okay.
What we discussed with Donna was issues that were beyond the discussion matter of the tenant lease agreement that we thought we were meeting with regards to the mediation activity.
Got it.
Your Honor, it all occurred during the mediation process, the confidential process. The report was filed after Ms. Tope.
No, I get, certainly get that part.
Moreover, Judge, I've done hundreds of mediations or many more than that. And yes, reports do go to the court, but the substance of the discussions never go to the court, just that what happened as far as if they came to a resolution or not.
But even to the extent that they're relevant, that report comes from the mediator. It doesn't, I don't get this. That's why when I saw it, and I was reluctant to even read it and just skimmed over it because I didn't ask for it. I mean, if it went to mediation, so the first thing that I did is I went to the leasing contract basically, or wherever it was, to determine if for whatever reason, as part of that provision, I was supposed to get it because I couldn't figure out why I was getting this. And that's not in there. And so I couldn't figure it out. Is there, given all of that, does anyone have opposition to the court striking the response to the court?
Both, Your Honor, the affidavit as well as the response, which then recounts the response to our motion. When
everything. I'm talking everything, because none of it should have been here. So I'll ask you, Jerome's, do you guys have
Yes.
any?
We do not. Go ahead, please strike it. Thank you.
Okay. Miss Tope, because she's a party, I gotta ask, you have any, given what's been said, do you have any objection to their motion to
None.
strike?
None,
All right,
no.
then please prepare an order to that effect.
I would still ask for costs and attorney's fees, Your Honor. We had requested that this be withdrawn to avoid the necessity of filing this motion.
Ms. Tope,
Can you-
why didn't you withdraw it?
sorry?
Why did, let me ask this, Ms. Rosen, who did you make your response to withdraw to?
My email to request that they withdraw?
My response to my withdrawal of the letter,
I sent it to all parties.
okay,
So you sent it to the Jeromes also?
I sent it to the Jeromes and I sent it to Ms. Toth by email. I don't have a physical address for the Jeromes.
Gotcha. Okay, that's fine.
Yeah.
Okay, so why didn't? Okay, see, this is where it's gonna get hard. because
Okay.
I already know the answer to it.
okay.
Before you say to the Jeromes, is there a reason why you didn't withdraw the report to the court?
Is there a reason why we didn't withdraw the report to the court?
Right, why you didn't acquiesce to the request to withdraw?
We were not aware of the concerns
Yeah,
related
quite
to the
frankly,
court
yeah,
filing.
we weren't aware of.
Oh,
how
you
to-
both started talking. What were you saying to me?
Sorry, Alec, you go. You'll probably have a better.
I just said we were not aware of their concerns related to the court filing and were not aware of the need to rescind.
Well, and
Yeah, I guess ignorance.
you
was-
had no idea as to the ramifications of that happening. Did you?
Correct.
No.
Your Honor, can the court inquire of the Jeromes if they sought legal advice from Ms. Tope after we sent the email asking them to withdraw?
We didn't,
No.
we didn't seek legal advice.
Hold on, I don't. I understand the nature of why you may want that. I'm gonna have I'm very protective even as a judge as to what may be even parts of an attorney-client relationship and communication. So I'm not gonna permit that answer to that question. All right. Is there any reason you didn't acquiesce and just withdraw before?
I didn't acquiesce because I had set up the meeting. I knew what they were to discuss. I knew what the confidentiality agreement should have covered. Not as an attorney, but as a person who was trying to effect that section 38 in our lease that allows for seeking advice from the University of Michigan. The mediation service allowed to students no longer exists, and they do not provide that service anymore. And I was referred to the dispute resolution where the parties talk about the issues under dispute, which are the lease terms. And so when there was discussion that there was no discussion with me about what was talked about or agreed to or anything about the lease.
I no longer know what you're talking about. I asked a very simple question.
I know. Why didn't I acquiesce? Because I felt as if there was a good reason to question the applying court rules to the settlement meeting that I had set up that was specifically stated by the person who organized it that it was not mediation. So I felt like there was a way to talk about what parts of it were covered and what parts.
Okay, but listen,
Yes,
if all the.
which I did in an answer. I have an answer, but
If all
Your
of,
Honor, I included the mediation agreement that all parties signed indicating pretty clearly that, or quite clearly that it was confidential in two different spots.
yes,
And-
but that
and the application-
confidentiality was over the subject matter of the meeting, and the subject matter of the meeting was strictly the lease and the lease terms. The things that they went off on had nothing to do with that.
The affidavit provided started out by stating during the mediation process, this occurred. Mediation was still going on. If this was a conversation that the parties had in the parking lot after the mediation, it would be different.
Maybe.
Perhaps.
There was no mediator present.
I don't, Ms. Tope, I really don't understand. First of all, why you felt it necessary to give that to the court, right? That's the first thing.
Okay,
But then once you made that decision to do it, and then counsel points out to you why it shouldn't have been done, is asking you just to voluntarily withdraw it. And you don't, after looking at everything. That's the part I'm having a hard time with you not doing.
I understand your concern. I felt it was, since we had had such a long discussion about mediation and good faith, and we finally agreeing to try to effectuate the term in the lease and follow that, which is what I did. And the mediation aspect not being available, I felt that it was my responsibility to give you back what had happened during this discussion that you had made very clear that you would like to have us do. And so I did.
So why do you think I would need to know?
What?
Why do you think I would need to know?
I don't know, because you told us to do it.
Your Honor, clearly she's just trying to prejudice the
No.
defendant counter plaintiffs by providing false information to the court.
No.
She knew she wasn't supposed to.
No,
provide
no,
at
strike
the-
it.
At the last hearing.
It's not going to make any difference. The judge will not make any decisions based on that report. It was just saying what happened. That's all. And I have no problem striking it. It's causing such problems.
Costs and attorney's fees, and we'll let the court decide how to proceed.
I've listened to you, and the reason I was asking the question is, Ms. Tope, tell me why I shouldn't sanction you.
Because one of the things that comes out in this back and forth is that I am being attributed by the other party because I am a plaintiff in the counter complaint as having ulterior motives. And honestly, I don't. I'm just trying to respond appropriately to my responsibilities as the agent who has been managing this lease from the very beginning. And
Ms. Tope, that's not a real answer to my question.
I know. Well, but that's how I'm thinking. I'm not doing anything willfully, intentionally, or in an aggressive, oppositional way towards their clients.
And it doesn't have to be aggressive. It's still in violation of the confidentiality agreement, the court rules, the evidence, an opportunity to withdraw it. You didn't. So here we are.
And that is part of the story. But the other part of the story is, given an opportunity to withdraw it, I did it because I felt I had a responsibility to report what the judge had ordered us to do.
Your Honor, I don't see.
So-
I don't know where that responsibility came from. If it came from a court rule, if it came from the rule of evidence.
It came from his discussion, just like this. I totally hear what the judge said.
I told you to do that?
No.
No. Making things up right now. And it's improper, and she needs to stop doing that. She needs to stop making false statements to the court.
Okay. Anything else you want to say, Ms. Tim?
No, except I am not making false statements to the court, and I am trying to express my motivations. And you asked me why I didn't, and I tried to express why I didn't. You know,
Ms. Tope,
it's in your hands.
so here's what we're gonna do. Place in the order that I'll take sanctions and costs under advisement.
Thank you.
And I'll decide whether I'm going to order them. Because, and here's my reason. I typically don't, I realize there could be violations. I typically don't sanction attorneys if they've didn't sort of have ill will in doing what they did. And I understand one may look at that differently, right? But sometimes people do things just out of sheer ignorance.
If you don't sanction ignorance, I will plead it.
I don't think you have to plead it. I think we pretty much have. Thank you.
We'll go from there. Your Honor, I would ask just one last thing really quick.
See, I told you the minute Rosie started.
So
I'm like, why can't you talk? No, go ahead.
Is no longer about possession. Possession will be returned. And it's going to be just about compensation damages. I would ask if the court is so inclined and has the time, and once the Jeromes have attorneys, if you would be willing to engage in your incredible shuttle negotiations and allow us.
See, you've been talking to Mr. Fink too much, first of all. But
I've seen it in action, so.
yeah, I don't, and I really don't have a problem with that. And ultimately, if we could get the case to that point, I'm not gonna have a problem with that once we get to the final settlement part and do that. But I've got to make sure that the Jeromes have attorneys in place and that their interests are protected, and we could do that. So, yes.
There's another procedural matter. Sorry.
No, it's okay.
So, after Ms. Tope served, one of her notices, she filed a complaint that wasn't timely. That was, I think, her third complaint she's filed in this case. So then she went ahead and filed a fourth complaint. In the meantime, we had responded.
Fourth complaint.
We had responded to the third complaint and counterclaim, but now we want to, we have not yet actually officially answered the fourth complaint, and we needed an amended counter complaint. So I don't know if the court wants to give us a timeline for that. And there were two case numbers, so I think the court mentioned it consolidating those cases.
Well, they're gonna, right. I mean, the district court doesn't have a great way of doing that. So how much time are you gonna need? Okay, so here's gonna be part of the problem. Part of the problem is you're going to be filing an answer and a counter complaint, which is going to include the Jeromes, which are then gonna have new counsel swing in, right? So I think I'm gonna do it this way. I'm at this, and that was filed by Ms. Tope on behalf of the Jeromes.
Yes,
The fourth one.
the complaint, yes.
Okay. And do a separate order. I'm not going to require an answer to that at this time. Because I don't know, once the Jeromes get counsel, I don't know what they might want out of that part. Complete. I mean, I don't know what their position was.
Those were filed not by me as an attorney. They were filed by me as the agent for the Jeromes. I was
Okay, look.
their attorney till later.
You got to stop that. I mean, you really do. you can't like split yourself and say, I'm doing this because I'm doing this as whatever, but now I'm acting as, you can't do that. Because you're doing it, when you do it, you're doing it to justify you doing something, which quite frankly, I would agree with counsel, probably is in violation, certainly if not directly, the spirit of the order regarding your disqualification. So
Right.
you just need to stop it.
So I, Donna Tope, am not able to respond to anything that had to do with my operating as their agent before I became their attorney.
Hang on a second. I don't know how to answer that. Because what may end up happening is that Jerome's get an attorney,
Yep.
the attorney says, oh, heck no, she's not doing anything on your behalf. And they follow that, then you do nothing. Your agency at that point certainly ends.
Mhm.
All right. So I almost hate going here, but I'm going to. So you're going to prepare the order regarding no answer required until the court directs otherwise.
Yes, Your Honor.
Okay,
Is
fantastic.
there also a deadline for a counterclaim though? Because we filed a counterclaim in the third amendment, but the claims are going to be, we'll be adding claims for sure.
Answer and counterclaim. Just everything's on hold because it's not you delaying it. It's not the court delaying it. I just have to it's the court delaying it because I have to give to Jerome's time to do what needs to be done. All right, now without raising a new issue, what is the circuit court case?
I filed I called the sheriff and filed a report of an assault and battery at the property by Eric Cassidy and Paula Cassidy, and followed up with that with a civil complaint of assault and battery.
When did this allegedly happen?
In the early spring. I don't have any of that information with me. It's not pertinent here.
Around March 8th, I believe.
March 8th.
And it was during the process of her, she claims the event occurred during the process of her serving a notice on the property.
The notice to quit.
Yes, at that point, it was to allegedly people that weren't supposed to be living in the house that were living there. It wasn't true. And then, I guess, Your Honor, the question will become, that did occur during, I think it's a permissive joinder, sure, I don't think it's a mandatory joinder, but it's a permissive joinder, so then the question will become, will we be removing our case to circuit court and then join that as well?
Okay, so this is like Groundhog Day. If you remember the first time that you were here, and we were going around and around about that, and I said I could do something that I really don't want to do, and that is get appointed a circuit court judge and just deal with it. And I just let you know what I'm thinking. Excuse me for the pause, and that is, I don't think you should be taking up Judge Connor's time with something that is a result of a landlord-tenant case that I have. If it's regarding the serving of a notice, outside of the landlord-tenant, why would you and the Cassidys even be in contact with each other?
I wasn't in contact with them. I was outside. So, Your Honor,
your entire relationship with the Cassidys is a result, it comes from this landlord-tenant relationship. Right? That was a question.
yeah, no, yeah, absolutely. I mean, the
Okay,
only reason
so-
I was there was in my agency capacity enforcing the lease.
Exactly. So why do I have a separate court hearing and action that came from that? Let me just say this. When was this filed?
Oh, August 8th.
Of this year?
Yeah,
You know, Mr. I'm just gonna tell you. And I don't know anything about it, but this is a lot like her. It's almost like you're just wanting to harass them.
oh my gosh.
Why, then answer me this.
Why would I do it? Because
Why wouldn't you file it if you felt that there was an assault and battery? Why wouldn't you file it in this case?
I didn't consider it a landlord-tenant case.
Civil actions up to 25,000
Mhm.
are the jurisdiction of this district court.
Yeah, I asked for over 25,000,
Ask for what?
over 25,000.
Of course, everybody does. So then why wouldn't we have just done it? And then we might have been back in that whole discussion about, does it get removed? Does it do whatever? I mean, I think this is, I can't help but think while all of this is going on, and quite frankly, you're not getting your way on a lot of things because some of it I
No,
don't
right.
understand. No, you don't. Listen.
Yeah. I'm listening.
That what you did is you took that case and almost as an abusive process, filed an action in circuit court to harass the Cassidy. That's what it looks like. So here's what I'm gonna do, because I don't think they should be trying to answer.
I will
two
withdraw
different-
it.
No, you do what you want to do, because I'm just gonna call Judge Connors in the circuit court and I'm taking, with his permission, I'm gonna take it. Because there's no reason he should be handling it. All the issues, God help me, but all the issues are here.
It was an assault against me personally. It has created a hostile work environment. I am afraid to do my
This is worse
job.
than like being civil. Either we're talking about you personally, we're talking about you as an agent, or we're talking about you as an attorney. You gotta make up your mind.
And Your Honor, all of these issues are what led to the tenant's decision to vacate. I realize that if they can tell us where to leave the keys, I will Mr. Cassidy's on the call. I'll know where to leave the keys.
Mr. and Mrs. Jerome, where should they leave the keys?
It's brothers and sisters.
Mr. Okay,
Ideas?
yeah.
I don't know.
said-
I'd have to think about that. I
Yeah,
don't know. This is such I'm
just-
so disoriented by this whole thing. So I have to
Can they leave the keys
get
in
back to
property?
you.
Is there a lock? I thought there was a lock box on the back door that we could place them in.
Is there?
Yes.
Okay.
Perfect. That works.
It's easier. They can be brought to my office. I did want to make just a clarification for the record. She filed her complaint on July 18th. July 12th, this court heard argument to disqualify and order disqualification. And then 6 days later, she filed it.
Hey,
I withdrew.
I knew you would.
I withdrew within 7 days.
You withdrew what?
I withdrew as attorney on this case.
You really didn't. But that's okay. You were disqualified. And for very good reason. And I did it. And everybody can be mad, but I did it. So here's what we're gonna do. Where do you Is there a lockbox back there?
Yes, there is on the back door.
Do you, I mean, Mr. Cassidy, do you know if there's,
Hello, excuse me, Your Honor. There is a lockbox. It actually has keys and it's on the door. I don't know the code for it. We can simply leave the keys in the kitchen, and they have the lockbox keys that they can enter the house. Or we can.
do you have a problem with that, Mr. If
No,
they
no,
just-
no, that sounds great.
Okay,
Those
just
are-
leave them in the kitchen.
Okay.
All right. Just take a picture that you left them, so I don't have to deal with whether or not the keys are there. What?
Yes.
Do we have a date to return?
Yeah, I really don't want to get one, but I will. She says with a smile. Do we have a date to return? Mm. All right, let's do it this way. They needed at least 3 weeks out. He was looking at, why don't we get 4? Why don't we make it September 20th? Will that work for you?
Fine, Your
Yes, Your
Honor.
Honor.
I've scheduled a mediation in the afternoon on that day.
And this would go in the afternoon. So what about the 27th?
I believe I'm available as well.
Would you be available the 27th?
Of September.
Yes.
Yes.
All right. And I won't say Mr. and Mrs. Will the Jeromes be available on the
Yes.
27th?
We will make ourselves available.
Okay, that gives you a little bit more time than the 3 weeks, but.
Great.
Clock again, Your Honor?
Well, I don't know. I set it at 9 and then my staff will send you notifications of the time. All right? Thank you.
Thank you. Your-
Once I get there, I am. And Mr. Fink?
Sure.
Ms. Rosen did something sort of in your name and made me commit to something. She'll tell you about it.
Well, that's it for the Simpson block. That was a little heavy-handed. That was a lot to take in, and that was long. So, finish things off. I put together a little bit of Fleischer, a little bit of Judge Fleischer to soothe the soul. These are some really good cases, in my opinion. I hope you enjoy them as much as I enjoyed putting them together for you. Enjoy them together.
All right, Judge, next is stage 2, Barnett, come on up.
Remove the sunglasses from the top of your head.
Pastor Barnett.
Yes, sir.
It's Barnett. You're charged with theft. You're facing up to 6 months in jail and or $2,000 fine. You were on bond for 1, 2, 3, 4, 5 felony thefts. And now you've picked up another theft. Not only that, you had 1, 2, 3, 4, 5, 6, 7 prior thefts before that. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, man. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I'm going to tell you now, if I find probable cause, I'm not giving you a PR bond. You have upwards of how many thefts? Please.
Thank you, Your Honor. On April 24th, 2024, loss prevention officers at Walmart viewed defendant surveillance cameras, passing all points of sale with unpaid merchandise and failing to return to purchase the merchandise. The defendant was seen to walk towards the checkout counter with a tinfoil tray and other unknown items inside plastic bags, passing all points of sales without an attempt to purchase the items. The complainant provided a value of each of the items taken by defendant, which showed to be 1 tinfoil tray, value of $4.98 each. If I had continued, or the officer continued to view the security footage and observed the defendant walking through the store, placing multiple items into her shopping cart, but never approached the checkout counter to purchase any of the items. Further investigation revealed that defendant had at least 2 prior convictions of theft.
What all the ones that she's on bond for now? What's going on with those?
Your
What
Honor.
are they for? Is it all Walmart stuff?
So I can read off each one. The one from March of this year, Judge, that was an HEB. The one from August of last year
Is HEB?
is HEB. The one from March of last year, let me double check that one.
I mean, we might have to bar her from every retail store in Harris County. No going to Target, no going to Walmart, no going to HEB, no going to Macy's. If it's a store, you can't go to it. You're incapable of going there. Where else?
2 more HEBs, Your Honor.
I think
They were all HEB.
all HEB, Judge. All of them.
I don't know what type of universe you think that we will continue to give PR bonds for this type of behavior, but I'm not going to stand for it. And I'm going to tell you now, I'm taking this and I'm going to make it really high. And I'm going to tell you, I'm going to put a GPS monitor on you. And I don't know if you're going to get out, but if you do get out, I'm ordering you not to go within 1,000 feet of any HEB whatsoever, and any Walmart, any Sam's Club, or any type of store that is related to HEB. Do you understand? And if I find that you violate that condition, I will quadruple the bond that I'm going to make now. But I'm going to probably set the bond at 10,000 with what all your felony cases are. It's unacceptable. Does she have all PR bonds on those as well?
Let me check, Judge.
10,000, 10,000.
It looks like it wasn't, so the felony was a surety bond that was reinstated.
Looks like they're all set at 10,000, Your Honor.
They were surety bonds that were reinstated in subsequent.
Okay.
Surety.
I am now revoking your bond. She goes with you. Please do not send her down though, because I'd like to sign conditions and then we will appoint your lawyer today, man. 10,000 and 1, 2, 3, 4, 5, 6, 10,006. No going to any HEB, which is probably something that she already has now as it is, right? And then no going to any Walmart, Sam's Club, or anything owned by the Waltons.
Is that state's bond conditions?
No, because it's going to be with pre-trial, because I'm putting a monitor on her ankle so we know where she is at all times.
Yeah, it's any HEB, because they were all HEBs and felonies, but it is.
Okay, right. So do you mind waiving the fee and it's prior to release? Okay.
All right, Judge, page 18, Williams, come on up.
No.
Good morning, Mr. Williams. Sir, you're charged with liquor sale without a permit. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Sir. Okay.
On August 17th, 2024, at approximately 2:04 in the morning, Vice Squad entered V Live. Apparently V Live does not have a liquor permit. They purchased a bottle service from the defendant for $200. He brought them a bottle of Crown Royal from the back room. A bottle of Crown Royal?
No. But is that a club?
Yes, it's a nightclub.
The nightclub doesn't have a liquor permit?
Apparently. It was also
Is he the only one in the whole club selling liquor?
It was also 2:04 in the morning. It might be.
Stand, but a bar usually has more than just one.
Yes, Your Honor. Defendant also did not have a TAPC bartender's license.
Mr. Williams, I'm going to find that there's probable cause to go forward with the case. Are you working at this point? What are you doing with yourself?
I do security every now and then when I can get a gig, but other than that, I lost my job. I was managing another bar. I was about a month and a half ago, but they closed down. So I'm in between Houston and Austin right now, staying with my parents and a friend when I can get work down here.
You want me to appoint your lawyer?
Yes, please.
Okay, I can. And I got to figure that, when you try to go get a job at a bar, you kind of assume that the bar is going to have a liquor license. And then it's their responsibility to get the license. If they don't get the license and they're not smart enough, or just someone else has to pay the price for that stupidity. What kind of sense does that make?
I have just lapsed, Your Honor. I don't.
I get it, but how does he have to pay the price for the bar's stupidity, the owner's stupidity? It should be on the owner. I'm going to give you a lawyer today. We're going to revisit this more. I don't know how much I agree with it. I'm not putting any conditions on your bond. Just be careful. Don't pick up any new cases. That's all I'm asking you to do. Okay. I'll give you a lawyer today, and then let's powwow and see where we go from here. I do need you to fill out an application for me. Deputy will give you an application. I'll have you sign a receipt, and then just don't go, and then I'll have you talk to someone here momentarily. Okay. All right, bud, please.
A few minutes later.
Who's Jeremiah Williams? Come up, sir. You put here that you make $3,500 a month.
No, that's not me. He said it's for everybody else in the house with.
Okay, who is that?
The officer that was in there, he said it's for my parents who grew up in the house with.
Okay, who do you live with?
So I stay with a friend when I'm down.
Okay, so it's just a friend. Okay, so it's not like your mom or dad that you're living with, that, or a girlfriend or something like that. No? Okay. I wanted to know because it's whether I'm going to appoint you a lawyer or not, right? So I need to know how much you make, and so you don't have that. Okay, so I'm still going to appoint you a lawyer because on paper it looks like you have some kind of income of $3,500 a month, and if you did, I wouldn't appoint you a lawyer. So, but I will appoint you a lawyer regardless. Okay, for sure. And I got to figure, in his situation, he goes to work at a bar. You don't know they have a liquor license.
There's more to it, Judge, if we can represent it, but we'll wait for him.
Okay, because that really makes me mad. And I mean, I would go after that bar like crazy. I'd sue the,
So that we did, but I'll disclose that with.
Okay, good. All right, so let's do that.
Yeah.
All right,
There's
so
more to it, we'll present it with the attorney.
please, just go ahead, take a seat with me. Don't leave. I'm gonna get you a lawyer now, okay? Thank you, Mr. Williams. Damien. Okay, Brent.
Right, Nicole?
Kenneth Green, come up. Fleischer. Just so you know, you're not here alone. Your lawyer is here with you online, on Zoom now. I brought you in here because you have bond violation. So at the outset, Mr. Green, with us, you picked up a terroristic threat. So you've been on bond for that terroristic threat since January of this year. 2 months after that, you pick up a felony theft of some kind of copper, or what was it? A catalytic converter
It was copper wire, Your Honor, from an AC unit, approximate cost to repair $4,500.
I ordered you to have a GPS monitor, right?
Yes, sir, I've tried to pick up that case. Yes, sir.
What I have here, the client has conditions from April 15th that include a GPS device with a curfew of 9 p.m. to 6 a.m. The client is not following his curfew as imposed by the court. On 8/4/24, unapproved, enter at 9:27. On 8/7, unapproved, enter at 11:02 p.m. On 8/8, unapproved, enter at 10:01. On 8/8, I'm sorry. On 8/8, unapproved, enter at 10:01 p.m. 8/8, unapproved, leave at 10:09. On 8/8, unapproved, enter at 11:47 p.m. 8/10, unapproved, enter at 12:40 a.m. 8/10, unapproved, enter at 9:36 p.m. 8/10, unapproved, leave at 11:53 p.m. Unapproved, enter at 12:24 a.m. 8/14, unapproved, enter at 10:12 p.m. 8/15, unapproved, enter at 11:10 p.m. 8/16, unapproved, enter at 9:10 p.m. 8/19, 2:01 a.m.
Judge, if I may,
Okay,
you contacted me on Tuesday morning, advised me of the bond violations. I reached out to my client, who states that he didn't commit these violations. He thought that his GPS device might be malfunctioning, so he went on his own behalf to pretrial services and was told that the monitor was not working, and he was given a replacement one yesterday.
I have here as of 8/19, there's no GPS, no cell, 24 hours. Client has been in no GPS, no status since 8/18/24. So his thing has been inoperative since 8/18. I'm revoking your bond. He goes with you. Sorry, Brent.
Judge, could we have a hearing on this where I could call somebody from pretrial services? Just
Absolutely. Why don't we roll it to Monday and we can do that?
Okay. Thank you for the
It's gonna take
opportunity, Judge.
time.
Eventually.
So, no.
Dundee.
We'll have to wait for Bob.
We're gonna approach on Mr. Williams. It's the liquor case, Judge. You wanted to readdress PC, and he had some more information.
Really chaps my, you know what? Because the way I read it, or the way I heard it, right? It's, and maybe I don't know all the facts, but.
On him? Yeah.
So he's working at an establishment. He's a
Not even
bartender.
working on it, but anyway, well.
We'll get there, but from what I hear, he's working at this place, right? I guess someone comes in, whether it's officers or TABC or whoever, and then they arrest him for not having a license, right? But I assume that's on the bar to get the license. But anyways, let's go forward. You tell
There are two
me.
ways to charge him under this statute. There's either charging him without having a permit to sell liquor, which is what we charge him with. There's also one on the manager that you can get, or the owner of the establishment, on selling liquor in the wet area or in the area that you own. So we charge him with selling the liquor, and we charge the manager with distributing liquor in the area.
What about the owner? Whose
We
responsibility?
charge the manager because that's the highest up we could get to at the area.
How can you not get to the owner, who's the person who's supposed to get all the documents to run a business? It's their responsibility to reach out, get licenses and
Well, it's also
appropriate permits. That's what.
It's also up to the manager to distribute the said liquor, right? So the
No, but it's not the
licensing.
manager's duty to get the actual license. That's the owner. The owner goes, applies for the permits with the TABC, because it's really hard to get a liquor license. It's not easy.
I know, and the manager does have knowledge that they don't have licensing, because the licensing needs to be.
I agree with you there. So I guess if they're on notice,
Yes.
it's their responsibility to
That's the way.
either don't work there,
Yeah.
right? Or inform them and just cease all business until you get the appropriate documents, right? So if you're going to continue to do it, then I get it.
Yeah.
Right.
So I revisited the way we charged this defendant, and it was no seller. So we charged him correctly. We didn't charge him as the owner, we charged him as the seller.
Let me ask you this, and because I'm not knowledgeable on this, but let's just say every bar in existence,
Sure.
in any bar in the city, we got it. There's hundreds of, not thousands of bars in Harris County, as
Sure.
big as it is, right? Are you telling me that every single bartender has to be TABC, has to have a TABC? I was a bartender at Chili's. I never took that. I never did any of that.
I can tell you, as I have friends who are bartenders at bars, and they do have trainings and they do get permits to sell liquor. That is something that you're required to have to sell liquor. So I can't tell you about a specific establishment.
I remember, God, it's so long ago. I remember taking a TABC class, right?
That's the license.
But I went to chef school, so I don't know if I did it as part of my chef school stuff but I've worked in restaurants all.
The TABC class is $11 on live. That's the bartender's license.
Judge, if I also may, I was trying to pull up the case for me, but I just got attached to it and it's not letting me. But in talking to Mr. Williams, he informs me that he doesn't even work for the establishment. I don't know if Vice even took that extra step to validate that he was an employee there. I think
He's behind the bar.
Well, no, I think what happened was just from my understanding again, and I don't have Jim's, but I think they saw, basically he was there and he helped one of the dancers to deliver.
Is it adult? Is it a?
So he helped deliver a bottle to the client. No money, nothing. He took the account and that's what they saw. But I also believe that if they could have just taken that extra step to even verify that he was an employee, then true, everything, the requirement, but he doesn't even work there. So there's no way that he can get a license to sell if he doesn't even work there to sell, Judge.
So why take a bottle?
Well, he was trying to help one of the girls.
Well, you hear that?
Well, what? Well, I just simply told him.
What do you
Mr.
think?
Williams told us.
I wanted to rope you into what John D was saying.
Well, I simply told him
your position.
What we saw, which was, he doesn't even work there. Unless you want me to, I don't have time to verify that, but.
And I mean, look, right, you just got in it, 20 minutes ago? We can revisit on Monday if you want more time. I'm always game to, don't have to really make a decision now. We can postpone it. I mean, I found probable cause now. I'm always willing to revisit if you have something else that sheds light.
I think basically if we just somehow make a call to the established to verify if he's an employee. If he's not an employee, then there's no requirement for any of this because he's not even selling.
I don't know. That's
Since it is an adult entertainment establishment, I'm going to assume that most of the employees at the adult entertainment establishment are independent contractors.
Well, I mean,
I don't even know how it works. Like as
I
far
would
as
say, again,
there's so many.
They still would have
over there.
They still would have him as an independent contractor. But if he's not even in the establishment, and then they may not have any records on him. If that's the case, then he's not even associated with the establishment.
Regardless, Your Honor, the undercover gave the defendant $200, and the defendant came back with a bottle of alcohol for the.
Well, anyways, yes, it's your call. All I'm saying is that's the facts that I have, and I just wanted to
Bring me more. Because from what they're telling me is that you say that someone gave him $200. He brings back a bottle of booze.
Yes, Your Honor.
Bring me more, and I'm happy to revisit it.
Okay, so PC good at this point. Let me just get a normal reset, Judge, because I'm not going to even be here on Monday. So we'll revisit that as a factual.
Andy, I didn't put any conditions on him. I just be careful. Don't pick up any new cases. Know where you are. No. I mean, you're in the wrong place at the wrong time. You know what I mean? So just be careful. That's all we're asking you to do, okay?
Okay.
You're in good hands. John will take care of you. Make sure you stay in touch with him. If he tells me he can't get a hold of you, I will issue a warrant. So just be careful, okay? Okay, my friend. Take care.
So much later that the old narrator got tired of waiting and they had to hire a new one.
John D. Hi, are you?
Judge, this is Ms. Miles.
We're Miles, Attorney Long Miles. Nice to meet you, Your Honor.
Nice to meet you.
We're approaching on Ms. Barnett, Judge. This was the judge, this was the case that you upped the bond, the tenant paid them to match her felony bond. I wanted to revisit you on that.
Okay.
And Ms. Miles is good enough to be here.
Long Miles.
Long Miles, I'm sorry. All I heard was
Representing
Miles.
her upstairs?
Yes, and
You represent her upstairs?
Correct, Your Honor.
so she has some history with this defendant, so I figure both of us will approach together.
Okay.
She had a PR bond. Judge.
Happy to talk.
I'm sorry.
Thank you for coming.
Yes, Your Honor.
Appreciate it.
And she may sub me out, but not officially yet. And that's why it's another reason why it's good for her to be, partake in this conversation anyways. We'd like for you to maybe consider, a lower bond, if not keep the original PR bond, just because she was given a PR bond by a magistrate. She knows more about the felonies and all that. So if you have questions about that, I'm going to defer that over. to her.
John, as much as I love you guys, right? What's your last name again?
It's Barnett, Your
Barnett,
Honor.
that's right. Miss Barnett has,
I believe you were going to refer to her felonies, Your Honor.
I see five felonies.
so Miss Barnett has a theft from 18, 2 thefts in 19, 2 thefts in 20, 2 thefts in 21, a theft in 22, and now she's charged with 5 felony thefts from 22 to 24, and now she's picked up another theft. So she's on bond for 5 felony thefts, not to mention 7 prior thefts. While on bond for that, now has picked up another theft. How on earth can anyone with that kind of history and you get another theft, get another PR bond? To me, what that does is that enables. And it tells you that, hey, that's okay because you pick up, even though it's a lonely misdemeanor, we're just going to let you out and, hey, okay. Maybe on your 8th case, maybe on your 9th case, we'll say, okay, we're no more PR bonds. I can't justify that. It's not.
Judge, would you consider that the fact that her felony bonds are set at $10,000? And of course, this is a lower case. It's a misdemeanor court. Maybe we could give her half that much or anything lower than that because it's not the same equate as the felony case.
You mind bringing Miss Barnett out, please?
She's also on the deferred.
Whoa, whoa, did you hear that?
Surprise to me.
Did you hear that? Go, another kick in the ding ding.
Your Honor, obviously that screams something, but we can bring her out and discuss it.
Let's do it because how are we supposed to have sympathy?
No, I'm not asking for sympathy, Your Honor. I'm not asking.
Hey, I know you don't know this, but is it HEB over there?
Yes, it is.
No idea. No idea.
It is a HEB store, Your Honor. I believe it's a tin pan that she's accused of taking.
Here.
In this case, it's a tin pan, Your Honor, worth about $5.
Right.
So 7, it's not funny, man. 7 prior thefts. You now are on bond for 5 felony thefts here. And you're on bond for you're on probation?
What are you asking?
She's
Your
on
Honor?
probation in, what is it,
Yes,
Fort
Your
Bend?
Honor.
You're on probation for a theft in Fort Bend. And you now pick up another theft. What's going on, Miss Barnett?
Your Honor, if I may speak for Ms. Barnett here. obviously something is going on that was addressed in Brazoria County, which is why after she's been in custody since, I believe, May in Brazoria, after so long, they decided to release her on bond because that is a shocking number while on bond. Also, I approached in felony court this, I believe, last week, and Judge Hill decided to reinstate her bonds there and not raise them or revoke them because we are considering what you are alarmed about, which is there is a bigger issue here. And so when you look at what she's being accused of, and these are accusations in all courts, she's being accused in this particular case of taking a tin pan out of HEB. And once again, this is an accusation. I understand looking at the amount as opposed to what is actually alleged. And that is shocking on its face. But also I would ask the court, I did not ask for a PR bond, or I'm not, her attorney, Mr. Duong, is not asking for a PR bond. He's asking for you to consider a reduction, Your Honor. Yes. Simply because of the type of case this is, the fact that she had the courts in Brazoria and upstairs are looking at the allegation here, and they did consider reinstating her bond. They did consider giving her a bond because they are seeing something bigger here. And I ask that you look at that and consider a reduction in her bond here. Because obviously, if we have an issue with a $5 pan, we have an issue with probably making that bond and her sitting this case out in custody and causing for a backlog in the docket.
I don't know, Ms. Barnett, I don't know if you have some unfounded sense of entitlement, meaning that just because you're you think that you can go in and take whatever you want. But to me, the amount has no bearing. It's the fact that it happens over, over, and over, over, and over, and over, and over, and over again. And the problem is there has to be consequence to behavior. You were old enough. How old are you, man? You are 48. You were old enough to know that actions have consequences. And yet it continues to happen. Why? I have to figure that you have at least $5 to $10 in your pocket to take a $5 pan. And now because of a $5 pan, you're now going to end up with a $10,006 bond. Now I'm going to make, well, now it's 10,007 because you're on probation. Why? And you know what? I shouldn't be asking you that because I don't want you to get into the facts of the case, but I appreciate you coming down. I appreciate your tenacity. But sometimes we have to save people from themselves. You are your own worst enemy, and it sucks. I hope that, do you have any kids?
Yes, sir.
How old are your kids?
28 and 30.
Are they like you?
Yeah, no, that's
Judge, I got her daughter's number, Desra, and I have not had a chance to speak to any of the family. This is all new to me.
Yeah, I'm just, you know, because the apple doesn't fall far from the tree. I mean, do you want your kids to be like you?
No. They're not like Your Honor.
So, but you, with all this stuff, you were showing your kids that this is who you are. I understand, and I thank you, Ms. Longmiles, for coming down. But when you're on 5 cases, and then now we learn she's on felony probation as well, and now you've picked up another case, I can't, in good conscience, give you a PR bond. And the appropriate thing is to set your bond to what the felonies are. You know, it's not fair that you continue, because what I told them, and they want me to let you out. They want me to give you a PR bond or lower the bond. And if we do that, I think that it would be telling you that it's okay to engage in this behavior. We would basically be letting you out and say, hey, you can pick up another case, and here, we'll just let you out again.
I mean, it's obvious that, if I may, that this is over a $5. So there has to be more in the psychology of her decision-making process. And again, it is not a felony. And it's, if her counsel has already implied that felony and the probation court.
I will make you a deal. I will make you a deal, John D. What I'm going to do is I'm going to keep the bond as is. And what I want is I'm going to set her for a TRAS today. And I want to know why it keeps happening. And I want you to talk to my clinician. There's a reason why. Is it kleptomania? Is it the excitement of doing it and not getting caught? What is it? Why? It's a $5 pan. You got to know that if you're on bond for all those cases, if you pick up a new one, you're gonna get in trouble. You got to know that. So why? It's got to be a reason. If she's honest on the TRAS, then I will consider a bond reduction. I will. But I want to do a TRAS and I want her to be honest. And if the TRAS comes back and it tells me that you're all gumdrops and ice creams and tulips, I know it's not true, and I'm not going to do anything for you. But I want to get to the bottom of why it keeps happening. There is a reason why it keeps happening. It's not for shits and giggles. There's a reason why it keeps happening. And we need to get to the bottom of it before you really do irreparable damage.
Judge, will you consider that there's two things. If you take her in today, she's going to be automatically processed and come back on Monday. Are you subbing in for sure?
Yes.
Okay. If that's the case, never mind, because I wasn't going to be here on Monday because I'm out of county. But secondly,
you can always zoom into. We have Zoom so that even if you're not here, if you're out of county, or if you're in Abu Dhabi, you can still come in and we can talk. We have the Zoom.
Judge, the other thing that I would ask is while we're waiting for this TRAS, and I don't know how fast that's going to happen, maybe we can just let her out until she goes to the TRAS, one way or the other.
I'm not letting her out. She has 5 open felony cases. She's on probation for a felony. She has 6 open felonies and she picks up another theft. I don't know what alternate universe you think that can happen and there's no consequence. I'm sorry. You will be staying with me.
So you would like for me to reapproach on Monday after I sub in, Your Honor?
Victoria.
I can send her first. Well, in custody will be on Wednesday, the 28th.
It's as soon as we can get one.
Because she has to process, so they just want to make sure she's in the right location. The other alternative is
What if we get her back on Monday and we can redo it on Monday?
That's what I was.
Yeah, let's do
That's
that.
what I was asking.
I'll get it done on Monday. I'll get it done. I'll get the TRAS done on Monday and then we can talk. I'm going to tell you now, though, I'm not giving her a PR bond. No chance.
I didn't ask for one.
I know, but I'm giving you guys a heads up now so that there's no preconceived expectation. It's not going to happen. I will consider a bond reduction, but I want you to be honest on the TRAS because I want to get to the bottom of it, Ms. Barnett. There's a reason. Why? I don't know, but I'd like to know why. And if you're honest, perhaps we can get down to it. It's better before you get to a 25 to life because it's going to happen eventually. Okay.
So the TRAS you're going to make happen on Monday?
Yeah. That's it. Yeah. Thanks.
Thank you, Judge.
Thanks, guys.
Ladies and gentlemen, don't go away. Do not change your Law 2 channels because we're going directly over to the programming currently in progress at Colin Not Cromwell's channel. Thank you all for coming out to see me and share these interesting cases with me this morning. I thought we had a slam-packed batch of interestingness. I don't know, the first set just straight up kind of crazy. But yeah, the Fleischer palette cleanser, you just can't beat that, right? That's just my personal taste. I love that. It may have to end up being like a weekly affair at this point. Hey, I'm not going to talk too much longer because we are going to turn this off and we're going to go over and check out Colin's video that he has going on as we speak. It's been wonderful seeing everybody. I do this every Saturday morning at 11 a.m. Central Standard Time, 12 p.m. Eastern. I will be having a live Judge Manning show coming up this Monday. Manic Monday, as always. Join us for Manic Monday. It'll be an hour and a half of some Judge Manning goodness. Look out for videos coming out all week during the week, and I will see you next time. Thank you for coming out.